Welcome back to another Harvard Alumni for Free Speech program on developments in Harvard University's litigation against the federal government over the cancellation of over $2 billion of government grants. I'm John Evangelakos, the president and one of the founders of Harvard Alumni for Free Speech. Harvard Alumni for Free Speech was formed several years ago by a group of alumni for the purpose of preserving, promoting, and protecting free speech, academic freedom, and viewpoint diversity throughout the global Harvard-Radcliffe community. Harvard Alumni for Free Speech is a non-political, non-partisan, and independent organization. Our members are concerned that Harvard's commitment to free speech, academic freedom, and viewpoint diversity, the core principles of liberal thought, have been threatened in recent years by intolerance and a willingness to subordinate these essential principles to other goals. Today's program is a follow-up to our previous program on June 27th, during which Phil Agusti, another HAFFS founder, summarized for us the parties' legal arguments and provided his assessment of their respective legal positions. The parties presented their arguments before Judge Allison Burroughs in the Federal District Court of Massachusetts earlier this week. And Phil joins us again today to review the oral arguments and discuss how this litigation may proceed. In addition to being a co-founder of HAFFS, Phil was a litigation partner at the highly regarded Washington, D.C. firm of Steptoe & Johnson before his retirement. Phil has over 4 decades of experience in a wide variety of litigation. Phil, thanks for joining us today. You were at the oral argument on Monday. Please tell us what you saw and what you heard.
John, it was a quite interesting oral argument, mostly for the reactions of the judge, which of course you don't see on papers beforehand. The argument by the Harvard counsel was very good and pretty much along the lines of its briefing and along the lines that we discussed on June 27. The thing that I would say is somewhat different on the issue, the key issue of whether Harvard is in the correct court, whether they belong in the district court in Massachusetts or whether they belong in the Court of Federal Claims in Washington, D.C., was not an issue that Harvard had to discuss very much in its presentation because Judge Burroughs at the outset said that she had read a decision issued on July 18th, that is to say the last business day before the argument, American Public Health Association versus HHS, in which the First Circuit, which is, of course, the appellate court that governs the District of Massachusetts, had decided that cases brought challenging grants was indeed in the right court, and she said right off the bat that she thought that was controlling, subject, of course, to argument. And Harvard wisely didn't challenge that. Harvard's arguments, of course, are basically threefold. First, they take the position that the cancellation of grants by the Trump administration was unconstitutional because the Trump administration first was trying to condition the grants on things that are improper. You can't require someone to change their political viewpoint in order to get a government benefit under constitutional law. Similarly, they take the position that the actions of the Trump administration to terminate the grants was in retaliation for Harvard's rejection of the administration's attempt to impose different political viewpoints on them. So the Harvard counsel pretty much went along those lines and largely repeated, and perhaps in better language, the arguments in the briefs. Second argument is that the alleged ground of anti-Semitism falls under Title VI of the U.S. Code, and that the appropriate procedures had not been followed under Title VI to have a termination of grants. Title VI is a congressional act that very specifically requires certain procedures before the executive branch can terminate a grant on the basis of racial discrimination, which of course anti-Semitism is. And finally, their position was that the actions that were taken by the Trump administration were not consistent with the Administrative Procedure Act. So their arguments are pretty much down the line with what they had put together in their briefs. There were arguments from the professors union, I should say, and some amici that were very consistent with Harvard. And then it was the government's turn. Uh, the government basically takes the position that this is a contract case, that each grant is a contract, and each grant, it is unquestionably under the law true that a government grant is a government contract, and on contractual terms, certainly is governed by government contract law. They took the position that there was a provision in the contracts that basically gave the federal government the power to terminate the contract for any reason that it wished. If there was any change in policy, they could simply terminate the contract. While the government did take the position that there was no constitutional violation, its theory there is that the April 11 letter in which the Trump administration made demands like taking over the admissions process of Harvard and having a very large influence on the hiring process at Harvard and doing audits of Harvard students' political views, that April 11 letter had just been a settlement offer. And so therefore, it couldn't be, it was null and void when rejected by Harvard and couldn't be the basis for unconstitutional demands. Judge Burroughs, by the way, made quite clear that she didn't really buy that factual argument. And so that position while a secondary position of the government, I don't think is one that certainly Judge Burroughs is going to go for. The government takes the position that the APA is simply inapplicable. The Administrative Procedure Act is simply inapplicable because the Administrative Procedure Act, by its terms, specifically doesn't apply when there is another remedy at law. And they would say the other remedy at law is under the Tucker Act, which is an act that requires all government contractors and government grantees to sue in the Court of Federal Claims, and brings into effect the whole range of procurement regulations. So they take that position. And on Title VI, they also talked about a response to the arguments of Harvard, but generally said that this wasn't a Title VI termination, so the Title VI is inapplicable. They said it was a contract termination. And
So
those were the positions.
sorry to interrupt, but maybe just for our audience, maybe we just kind of review what Title VI is.
Yes, Title VI is a congressional act that basically gave the executive branch the power to terminate, among other things, grants, research grants, among other things, in the event that the executive branch found that there was discrimination. That Title VI, however, has a number of procedures that it's undisputed that the government here did not follow those procedures. So if Title VI is applicable, then it's fairly clear that, and if we're in the right courtroom, it's fairly clear that Harvard would succeed in its lawsuit. But that was pretty much my summary of what the arguments were, John.
Mm-hmm. That's great. Let's I think just for the benefit of the audience, maybe we should kind of bore down a little bit into sort of an overall assessment of what appears to be happening. I think based on everything I've read and what you've told me, Harvard is a very strong case, I think, on the merits. In terms of both under the Administrative Procedures Act, which is essentially one of the government follow the right process in canceling these grants, to the constitutional issues regarding retaliation, coercion, free, forced compelled speech, etc. So what we're left with is really the government, this jurisdictional issue. Is this in the right court? And as you pointed out, this comes down to is something called the Tucker Act. Does that apply? And I think there for all, for you, those of you watching today, just to kind of reiterate a couple of things that Phil has said. Essentially, the act provides that a claim based on money damages under a contract must be heard in the Court of Claims in Washington, D.C. And so I think the question here is whether the claim that Harvard has brought is a claim for money damages, or is it a claim for something else? In this case, is it an injunction to prevent violation of constitutional rights? And I think there's a lot of case law. I think Phil is very, very conversant with that, and I think there is a case, Supreme Court case earlier this year, Department of Education versus Berkeley, which I think some people will say is squarely on point here, and is I think is going to be challenging, I think, at least for Harvard to try to distinguish. It's not impossible, but that ultimately that is what we're. I think that's sort of the main question here. I don't know, Phil, if you agree with that assessment, but.
Yes, I think that's right. And by the way, the case is California versus Department of Energy.
Thank you.
Department of Education. But in any event, yes, it was handed down in early April. And in that case, which was a stay case, which will be important when we talk later about what's going to happen further in this case, the court took the position in determining whether a stay was appropriate. Under one of you have 4 tests when you determine whether a stay is appropriate, and one of them is likelihood of success on the merits. And 6 justices of the Supreme Court found that California had little chance of success on the merits because the case was in the wrong court. It's the very same thing that we're talking about here, and that was a case where similarly, California and a number of other states had sought an injunction to essentially do sort of what Harvard is doing, and there are factual distinctions, but to prevent the government from stopping payment under a series of grants. And so that's why that case is so troubling to many observers of the case.
So Phil, let's just, again, there's a lot of injunctions, a lot of negatives in there, just to kind of lay it out, I think, for people. In the Department of Education case, as in the Harvard case, the plaintiffs were seeking an injunction to prevent the federal government from canceling or terminating these grants contracts. In the California case, they won, and there was a judgment that was going to be, there was an injunction had been issued, and the decision was under appeal. The First Circuit, which is the Court of Appeals, decided that they would not stay the judgment, i.e. not stop the injunction. And then that decision went to the Supreme Court, and the Supreme Court then decided to stay the injunction pending their hearing the decision at the Supreme Court. Is that just, I guess, to put it?
Yes, that's right. Yes, and they said that it was because the case was in the wrong court.
Yeah. So look, so maybe let's talk about kind of the implications of all this. Where do we go from here? And I guess we're going to put on our little prognosticators hats. And then we can also talk about why Harvard, given the choice, certainly they could have brought this case in the Court of Claims and the government would not have an issue. So let's talk about where we move from here, and maybe, and then why the Harvard brought this case in the First Circuit.
Sure. So let me first start, but with the last point that you made. Why did Harvard bring this case in a court that has a questionable right to hear the case? And the reason is, I think the principal reason, Harvard hasn't told me, but I think the principal reason is that if you sue the government in the Court of Claims, you have to wait until after all of the litigation is decided to collect any money. That's just the way it is under the law of government contracts. And so, if Harvard had sued in the Court of Federal Claims, it would have had to wait until they won in the Court of Federal Claims, they won in the Federal Circuit, which would be the applicable circuit, and they won in the Supreme Court before they saw any money. If, on the other hand, by suing in the District of Massachusetts and getting an injunction against the government withholding payment, or a vacator, if you will, which is a voiding of the government's order to stop payments. What that would do is it require the government to start paying money right away. So that's basically there are other reasons, but that's the fundamental reason. Now, what I think will happen next is that I think it's highly likely from the comments that Judge Burroughs made, and she was very polite and asked very good questions throughout the hearing. But it's relatively clear from prior decisions, from what she said about this issue of what court this belongs in, remarks that she made about government's theories during the course of argument, that she's going to rule for Harvard. And I would expect that she will rule for Harvard sometime in the month of August. Harvard has indicated that it is very important and that it will experience irreparable harm if the decision takes longer, goes into September. So, and she's heard that, and she has indicated that she intends to move swiftly on the opinion. Once that opinion is rendered, it will go to the First Circuit. The First Circuit is I don't want to talk about politics, but it is a heavily, the judges on the First Circuit are heavily Democratic. And what's more, they've just issued an opinion on July 18th, that American public health decision that we've talked about, that indicates that the Tucker Act cases and indeed the Supreme Court's Tucker Act case, California v. DOE, that I referred to earlier, is also distinguishable. And so I fully expect that let me just back up a moment. Once this is a final summary judgment hearing, so Judge Burroughs will issue an injunction at the time that she issues the opinion. The government will then ask her to stay the injunction pending appeal. And to do that, it has to satisfy a four-part test that includes the likelihood of success on the merits. While technically trial lawyers always do this to the district court judge, she's just decided that they're not going to win. So it's very unlikely that she's going to grant a stay of her own injunction. As I was saying a moment ago, they'll go immediately to the First Circuit in an hour and seek a stay of the injunction there, making the same four-factor argument in the First Circuit. And as I said, because of American public health and the inclinations of the First Circuit generally, I suspect that the First Circuit will not issue a stay of the injunction. And then what they will do is very quickly go to the emergency docket, also known as the shadow docket of the United States Supreme Court, and seek a stay of the injunction there. And that is a point of danger for Harvard, because as I mentioned before, one of the factors that you look at is probability of success on the merits. or I should say, likelihood of success on the merits. And so, in order to issue a stay, the Supreme Court has to decide whether Harvard or whether the government is likely to succeed on the merits on appeal. It has to think about some other things as well, but that's the most dangerous factor is that first factor. If the court decides, as it did in California versus DOE, that we're in the wrong court, they will stay the injunction, and essentially Harvard will be locked in without getting payments until after all appeals are decided.
That's thanks for that explanation. I think that's very helpful. Phil, maybe we should sort of jump to really speculate here and talk about the possibility of a settlement. I mean, litigation, it's all great, it's great combat, but most often in my experience, the parties settle because the risks are too high, and takes a lot of time and effort and resources to litigate. So how do the parties' strategy here fit into their various settlement strategies, assuming that that they do want to settle? And everything to me, I mean, the reports seem to be that there's still this ongoing discussions regarding the settlement.
Well, I think that the Harvard lawyers know what I've said much better than I do, and so they know the risks of this whole stay litigation that's going to happen almost immediately after Judge Burroughs issues her decision. It certainly would make some sense to think about reaching an accommodation with the government because, naturally, if it goes to the Supreme Court and the Supreme Court issues something unpleasant in connection with a stay, makes a decision as they did in California v. DOE, opining on the likelihood of success on the merits. That's not a binding decision, of course, but it certainly would give the Trump administration a leg up in any negotiation. So it certainly would make sense for Harvard to consider settlement. But of course, it takes two people to settle. And if the Trump administration were to stick to its April 11 demands, I doubt that the Harvard would be inclined to settle.
So, yeah, I think I think we're probably. I don't think there's that much more that we need to go through at this point. Phil, unless there's something else I think you want to add.
No, John, I think that we can go into far more detail in all of these grounds, but I think from the perspective of giving people an overall view of the difficulties that face Harvard and the government for that matter, I think we've done our job.
That's great. Okay. Well, thank you, Phil, and thank you all for joining us today. Harvard Alumni for Free Speech will continue to monitor this situation, and we will provide updates, as developments occur. Thank you for joining us. If you have any questions regarding the litigation or this situation or Harvard Alumni for Free Speech, please feel free to reach out to us through our website, harvardalumniforfreespeech.com. Thanks. Thank you very much. Thank you, Phil.
Pleasure, John.